small and tight. Not like you. Sarah's laugh rings through the night. Such a brute, drunk and silly, thought she'd play. Crazy witch, locked me in just for the day. Life's a bitch. Can't you hear me, Sarah, please? Hook out, bitch. Out of there, my lungs, they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Can't you hear me, Sarah, please? Hook out, bitch. Out of there, my lungs, they squeeze. Let me out, you witch. This is not a funny joke. You put your hands around my throat. Feeling trapped and nearly choke. Gonna croak. Sarah, let me out, I'm begging, please. Stop, I'm almost begging, please someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Dark and tight, I curl and wait. Are you passed out? You'd return my fate. You emptied my stash out. The game has turned to cruel. Why are you filming late? Inside I feel the fool. I can't breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as her castaway. Sarah, let me out, I'm begging, please. Leave this stuff, I'm almost begging, please. Pray someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Boom! Looking tight, I curl and wait. Are you passed out? Hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Why are you feeling me? Lost inside, I feel the fool. I can't breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. Breathing stuff, I'm almost begging. Please. Drink so raw, don't leave me here. Lost my air in this year. In this case, I disappear. Are you there? Sarah.
How's everybody doing this evening? Good to see you. Little Sumo Gemma. Good to see you. Good day, y'all. Anti-Pterodactyl, Roy Lone Singer, good evening, and Star Z, and I'm sure there's a bunch of other fine people there. And if you're just waiting to tell me that you don't like my channel, well, that's fine. We're going to do a little more Sarah Boone tonight. Jervin and lurking again. Excellent, Cynthia. That's the way to do it. Drive a little, lurk a little, enjoy the show. Here we go. We'll just might as well get this bad boy started off. Good to see you. Hi. All right, let's bring it on.
On behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Sarah Boone. Come back on behalf of Sarah Boone.
Swear or testimony you give, tell me the truth, whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone,
All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address state before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website.
This is rough.
I want to make sure I am crystal clear as to what the court has said is going to occur during the trial. regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office.
Thank you, Cynthia.
Anticipating type of
Appreciate
Okay,
it.
that's what I wanted clarification on. Thank you.
But I just do want crystal
you guys
clear
are awesome.
clarification as to what we are both doing, because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
Yeah, so what happened was the clerk failed to file anything. And that just had to do with time because they were doing the voir dire of
You did
the
not.
jurors. So that's why
Okay.
that's why it took so long. And there's a little bit of a delay.
Madam
here while
Clerk
they're
is advised
trying to
that
pull
court
those up.
minutes were not prepared for the ruling from yesterday
Yeah.
due to it taking place during the trial and jury selection. So Digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to
Crazy.
beg and plead if she's able to get me
Get on your
a
knees
copy
and beg
of what it
and plead
was
for me,
so that it can be
baby.
re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you?
David, how you doing? Good to see you, Air Force vet.
Is that acceptable? Can we address it at 1:30
Love it.
before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No,
Karen
I agree
Anderson?
with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed
No,
to
don't
say.
put him in a suitcase.
I don't disagree.
That would have been funny. He
But
said, I'm not
is
trying to put
1:30
anybody in a
acceptable?
suitcase.
okay, well then, short of taking a break right now and having her
Been awesome.
create it, I don't know what else
Not
to
trying
tell
to put
you.
anything in a box.
Finish jury selection. Mr. Henderson is going to take a minute. This afternoon, I guess we start at 10:30 or 11, and that's going to spill until probably late afternoon before we actually get a jury pick. And we just agree on Friday morning, starting opening statements. That gives her time, them time, me time.
State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 tops.
Okay.
And then we've got Goodreach jurors, clause, and territorial.
More
Correct.
sessions of physical therapy.
That's correct.
Awesome.
So that's going to take,
One more tape. Gotcha.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft
I
of
really
what
like
was
this judge. He's just solid. with
ordered
these
yesterday.
people.
And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions and
Make
limits.
sure that everybody's
Then we
following
can
along here.
continue with jury selection, or then we can pick up with the
Been
objections.
very gracious to
I'm
both the
amenable
defense
to
and the
however it is you
prosecution,
want to proceed.
making sure that
I
they're all
understand
running
your
their
concerns
show
of running
right.
afoul with a motion in limine.
You know,
I totally understand
no
that.
mistakes.
But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but
Judge
prior
is
to
good.
getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay.
There
All
you
right.
go.
Madam Court Reporter, how long do you
that's
think it
well
would
said.
take you?
Like, really push them hard on this stuff.
Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Mr. Owens?
Madam Clerk, so 30 minutes?
No, not that
Excuse me?
long. No, not that long.
Okay.
How long do you think? 10, 15, 20? Okay, great. All right. We'll be in recess till 9:45. Thank you. Yes,
Defense
sir.
did nothing but waste time.
Yes, sir.
Because there was another motion filed last time.
Yes.
I think it would have some impact in opening statement, of course. So if we deal with that now, that would probably help.
You're talking about the motion eliminating regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine.
Good. And just to make it quick, Judge, I've read the motion, I've read the text.
Miss
order
Stacy,
provided by the
got
state.
to see you.
Okay. Well, that saves me some time then, so I appreciate that. All right. So do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial?
No objection.
All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
And we're back.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state.
Yeah.
Stronger out the state.
Morning, Dave, the state.
Good business.
James Owens, Sarah Boone.
Tony Henderson's with Sarah Boone. Mr. Beckett.
Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you,
Hey, how you doing?
amenable to proceeding without
Good to
Mr. Beck
see you.
being here? Okay, thank you very much.
We are on fire tonight.
Oh, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Yes. Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Judge, was it emailed to us?
Sure.
Timmy Bugatti.
I didn't know.
Oh, yeah. Hey, CJ, how you doing?
Madam Clerk's providing you a printed copy, sir.
Thank you, ma'am.
Yeah, they're printing these things out. They got to get their
Bless
dot
you.
matrix printer out, slap some paper in it, tear the sides off of it. Hey, Ludwig, how you doing?
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Come on, take a look at it. You see it? Excellent, Ludwig. That's wonderful. I'm glad that you came in, Ludwig. I love it.
I appreciate it, Judge.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not.
Well, see, kids, the best part about it is they come in and then they get removed, and you never see them ever again. It's a beautiful thing. And just think, he had to wait 10 minutes to do that.
In our motion, though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida Fourth DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
That's the first, and I know it won't be the
I just
last.
have
Yeah.
One question as to what time? Are we talking about or dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 2nd 750, at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of the victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just my understanding, I'm clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from this person.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6th DCA.
Okay.
Yes, ma'am.
Yeah.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes. Just my overall understanding is that the motions and the orders that the court has applied to trial and the organization or the flow of the evidence
What's up,
Certain
Tracy?
transactions
How you
are
doing?
certain
Good to see ya.
It has nothing to do with or die nor open state.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for
That's right.
themselves. I'm not going to rehash that matter today.
Yep.
Anything else, Mr. J?
Hang on.
Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go 3, 4, et cetera. So we can ping pong it back and forth from there.
All right. Regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained.
Oh, nice.
Moving to 3.
Going to receive.
Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2.
No.
Talk about 3.
Well, I do need to talk about 2 now because
Okay.
this morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone.
Oh.
So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be, and we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay.
So what he just said, and I could be wrong on this because I'm not a lawyer, but I believe what Richardson's hearing is basically they're going to have to go through each one of these piece by piece, bit by bit. They're going to have to get an order on each one of them because this attorney effed around and thought he was being slick and sent him just a bunch of JPEGs. And once he was able to pull those things up, he was just like, yeah, these aren't the same thing that you submitted earlier to me and purported to submit to the court. So now we're going to have to go through each one of these individually. The attorney's just wasting time right now. He did that crap on purpose because it's not hard to take a bunch of pictures and format them into a PDF and arrange them properly. This is the kind, are they pulling stuff off her phone? No. This is like medical records and crap like that. But there's things in there that they never agreed to, hoping that they could get it past him. And he's just like, he more than likely got one of his staff to go through it. I need you to organize these pictures, make sure they're all facing the same direction, make sure that we can see everything that's in here. And then I'm going to have to review each one of these. Actually, no, he did that right beforehand. Yeah, this guy, Boone's attorney, Owens, is doing some shady crap. He's playing a game, and this attorney's not impressed by it. Like, if you're going to represent your client, do it in an honorable way. And this guy's just being a complete tool. So bad.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, in the defense bit, 50-minute reciprocal discovery exhibit list.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
The 81 pages are not at issue.
I understand. That they were given. They were given.
Yeah, they had no problem with the 81 pages. It's the 119 that you just submitted last night, you dimwit. He knows he did this.
Sarah Boone from the Advent Health Report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them, so we provided those to the state as soon as we were aware that we had not.
Right. Sure. You didn't send 119 pages. You sent 119 JPEGs. Do you know how difficult it is to do that if you're sending that through email? That means you had to send them in batches. Yeah, this was done on purpose. This is screwing around on a level that this goes to show how much of a case they don't have if they're having to do these kind of shenanigans. Yeah, exactly, Lulu.
And what do the 119 pages evidence?
They're medical records from the hospital relating to Sarah Boone over a period of time. Obviously, that's going to be whittled down depending on her testimony and whether or not.
Hey, good evening, Nelka.
Her testimony that she suffered an injury at the hands of Jorge Torres.
Yeah, defense sent it.
I need more specifics than that.
Yeah.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time.
Oh, Jesus.
So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
If you don't know this as an attorney, Stacy, the Richardson hearing is they decided at the last minute to submit all of these images to defense, okay, or to the prosecution in their defense. They thought they sent them before, but here they go at the 11th hour. They got 5 minutes to go, and they decided that they were going to submit all of these to the court, which he in turn had to turn it. That attorney, the prosecutor, had to turn all of those JPEGs into a PDF. He had to arrange them because some of them were upside down, some of them were left, some of them were right, some of them were upside down. He had to arrange every single one of those, all 119 pictures, make sure that they're facing the correct direction. And then he had to turn it into a PDF file and give it to him. Yeah, this is all shady. This more than likely was his staff. He probably told his staff, we'll get them the pictures. And because they're incompetent, his staff, yeah, the little blonde chicky baby that sits over there and has to dress in like I don't think what she wears is very appropriate for court. And this girl right here, so there's a little blonde girl that sits over here in the corner, and she's going to sit down with Sarah a little bit later and be adjusting her shirt, and it's like so it's like tasteless tacky. She looks like a Barbie doll. I mean, sure, she might be cute, but I guarantee you she must not have much of a brain between her. Hey, Taz, good to see you. Hey, Kimmy. Yeah, it's very, very shady, Kimmy.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
Yeah, so this girl right here is the dimwit that did that crap. She is the one that pulled this shit. Professor is getting old. That's funny. Yeah, they know what they're doing. This is all intentional. This judge could sanction him for this crap.
Judge, my understanding is the first 81 pages were medical records of Sarah Boone that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my...
Really? You have no idea? Yeah, he said, oh, we received them last week and then we figured out we hadn't sent them. Why would you do something like that? Except as a delay. Because this is ridiculous. Judge should just throw that out. Yeah, taxpayers' money. She's exactly, Stacy. Exactly. My thoughts precisely.
Secretary, we have to take a break and let me find out from the secretary when we'll receive it.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3, is this the Advent Health Winter Park Jorge, not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
Yeah.
You want the exact pages that those...
Yes.
The DAC and the narrative are on?
That's what's going to be offered into evidence at this point in time.
Oh, Jesus. Well, yes, yesterday, if you were watching yesterday, he talked about the over, I think it was 700 pages of back to Boone. That's right. There was over 700 pages of documents that the state objected to. There's just like there's no way that they need to be submitting all of this in here. We've got nurses rounds in here, just every bit of information, and he's just like this is not it serves no value being here. So this needs to be whittled down. Made good faith to acquire Boone's farm today and no dice. Doggone it. So yesterday, the judge ruled you need to whittle this down and submit it. It needs to be done today. You need to have it to them tomorrow. So that's part of what this hearing is for. Yeah, the defense is BSing around because they couldn't get the original delay they wanted, so anything to slow it up. That is absolutely true. That is absolutely true. And the judge is not having any of this because the judge just told him, yeah, at this point, you're going to offer it and we're going to deny every single bit of it. Every damned bit of it. And I don't blame him. I completely would too, because this is the kind of shenanigans you shouldn't have happening at all. It's just wrong and it's bad. It's wrong and bad. Oh, man. It is. And you're about to see the judge just go off on him. He's not playing around.
Regarding this motion, is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
Oh, I know it does. I've seen this.
You want the exact pages that those?
Yes.
The DAC and the narrative are on?
That's what's going to be offered into evidence at this point in time.
Judge, we'll work on that right now.
Appreciate it.
I've got staff here in the courtroom. They can work on it.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on response.
Yeah.
The objection is sustained. Moving to 6.
So the objection is to those documents being put in, like the objection on these are being sustained because the judge is not playing with them. He's done. He's done with their shenanigans. Like, you've had plenty of time to get these medical records, and if you haven't gotten them, you should have taken your happy ass down there with her signature and got them. No, this is not discovery at all. The only thing I could compliment them on is pulling all these shenanigans and stall tactics and not having to sleep in jail. There you go. Finally slept. Excellent, Taz. This right here, they're getting ready to go into. They're about to have, like, shit's about to hit the fan here shortly. It's going to get good. This is light compared to what happens. They're at one point, and I didn't even realize it. I was watching this while I was working, had lunch, came back, sit down, was nice and comfortable, and I fell asleep, and I didn't even realize that the hearing had pretty much come to a stall while it was filming, while the judge pulled them aside to go through each and every individual one of those, and then they come back and they go on the record. But I did manage to cut that section out, so there's about an hour of stuff that's not in there. Shouldn't all of this been put on Discovery? Yeah, there's certain things that they can put in at the last minute, especially if it's agreed upon. But yeah, a lot of this stuff is part of Discovery. This is just they're just trying to get to these are the brass tacks right before they go into court, because you would get all that stuff in Discovery and then you would whittle it down before then, before you show up to court, before you have all of the motions to make sure that you've got the jury instructions are correct and all of those things happening properly. And that's what this is. This is just to make sure that whenever they show up right before they do the opening statements, that's whenever this really begins. What kind of food should I order? What kind of food should you order? Let's see. What kind of food should you order? That would be, I'm thinking some wings. Some lemon pepper wings would be good, Brandon. Lemon pepper wings. A side of fries with some with some Parmesan on it. I think that would be good. Yeah. Nice and easy.
Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they've not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone.
Oh boy.
Once again,
Here it
I
comes.
spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state
Just push the buy button.
just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 22320, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And we struggle to see the relevance, Judge.
Thank you.
Oh, this right here. If I was the judge, I would just say then we're not bringing any of it in because this is ridiculous. But of course, he's not going to do that because he's a good judge. He's not like me. I would be just like, you know what? Tell you what, we're just going to do a bench trial. just saying. Got up, back to lurking. Good to see you, Heidi. Good to see you back.
Response.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed.
They addressed this crap yesterday. Those 500 pages were all of their documents that they're going to be using in trial. Do you wipe yourself with what? What are you talking about? Oh, I see what it is. Ah, boy. Here we go. Report. And we've got you. We got you there. And there you go. Report. And there you go. Good to see you. Bye-bye. Didn't just think that another person had to wait 10 minutes to do that. Yeah. They had to wait 10 minutes to do that. I think it's so enjoyable just watching them seethe, cope and seethe. Oh, been dealing with this since 93. Yeah, so here's what the judge told him yesterday. Again, it would be nice if they said something funny. I know, isn't it? It would be nice if they actually had something fun to say. But the problem with this is they gave the defense all of the documents that they were going to use for trial. It is not the state's fault that Sarah Boone can't keep counsel. Okay, and this has become one of those where, but they gave me these, and the judge is just like, listen, we addressed this crap yesterday. We're not doing it again today. It's not going to happen. So stop playing. Here we go. Back to it.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. It's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state
just
is
did.
taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon, not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence. Because, of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Uh-huh.
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition.
Because you're delaying the
I'll wait.
trial.
I will not ask her to review.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, is they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeated of 11, so the court's going to adopt its, similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of Jorge Torres not yet received by the defense. Has the state received that?
What is it about Florida that women feel that they have to get lip injections? Because those are clearly lip injections. Just saying. Why? Why? I don't get it. But that's me.
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses. But he's not a witness. So we have not done anything other than had discussions about the prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania and Massachusetts. We're not referring to those. We're only referring to the ones involved.
No, she wouldn't be able to do anything. That's the problem. I mean, they're all just puffed up. I mean, if she wants her lips to look like that, I mean, all she has to do is just like kiss a baseball bat a couple of times. That'll get those lips to puff right up like that. I mean, just saying. You have to do it on a daily basis, though. And they do tend to turn blue, but she's probably wearing enough makeup you'll never notice anyway.
All the incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because he can't rebut it?
Yeah.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Mm-hmm.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries, photographs of the officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that we have to cooperate it and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to.
Yep.
Whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge Park.
Yeah. So what he said here is where are the trolls coming from? I don't know. Probably. I guess so. I mean, I don't understand them. It's beautiful though, because I can go in and they get removed pretty quickly and then they can't come back. She's at a concert. She doesn't want to be there. She has to be there, but I can throw my own party. Oh, that sucks. So she's at a concert and she doesn't want to be there. Man, that sucks. That really sucks. But yeah, no, here's the thing that, you know, he's saying what we want is, oh, did you miss the third troll? I don't think so. I think we've got them all under control. Besides, it'll take them another extra 10 minutes to come back in and do anything. I put it in down for 20 minutes. You have to be a sub for at least 20 minutes before you can do anything. We ain't gonna worry about them. Don't focus on them. Let's focus on what matters. This is what we're talking about. This guy right here is a fool because he's trying to get things admitted in there, documents, and he's acting like he's stupid and incompetent. And he says, we're talking about physical exhibits, and that's what our objection is on these physical exhibits. Now, if you want to bring in, you know, images or something like that, then we have to know what they're in reference to. It's stupid and silly.
Objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I assume Dr. Harmon will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered, that she has nowhere to turn. That his family can't help her, she has no move. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted him to drop. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Williams says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was the victim.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the
wasted
prior
time.
criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup.
Well, either he's dumb or he's doing this to delay. It's one of the two. And it appears to me that he's hired. You don't get what he's doing. He's trying to get evidence admitted in and they're beating around the bush on this and not explaining it very well in court because they're trying to be cordial. But what he's trying to do is admit evidence in that would make the dead guy, the decedent, look bad as an abuser, as violent, and they don't have anybody that they're bringing in to verify this, and they're trying to sneak it in. His strategy is to accomplish anything? No, it is a delay tactic, and he's hoping that he can get some of this stuff through. He's hoping that the attorney is look up stuff on the fly. I don't know. I think he's just waiting for. Yeah, both of our attorneys are like this. Now, if you think this guy is dim-witted, the guy that's sitting over here, you can't see him. The fine-looking black gentleman with the bald head. Well, he's very easily confused. Very easily confused. She's
will
got
not be
3 of
offered
them
into
right
evidence,
now.
but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State,
Clifford. Yeah, right there. There he is.
any further argument?
I believe we went from 19 to
That guy right
21
there.
without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
Don't introduce anything on this one.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything
Yeah.
further, argument state. Anything further, argument?
No, sir.
Okay, I'm going to overrule the objection as to, as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act
Yeah,
concept
you guys didn't
is
get it in. That turned he's pissed.
placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-O. I understand the state's objection is to relevance and hearsay response.
Judge, Brian Boone, we anticipate is going to testify for the state, may testify for the defense, and he may be considered an adverse witness or hostile
Yeah, I
witness.
know.
So we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect for impeachment purposes the fact that he has not complied
I
with
can
some of
see
the
that.
orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5
Not
years.
as much as the
That was
blonde
not the
guy.
agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation
This is
going
about
on.
Brian, her ex.
Brian
They
Boone
want
has
to
not
exclude him as a
considered
witness.
that force, but they're-
What does the non-payment of alimony have to do with what's happening in a family case?
Well, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his
What does that have to do with
bias
this?
or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge or Ninth Circuit panel division. And I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some
Not
issues.
a Murdoch's kind of
She was given some kind of
flavor.
notice of the
Yeah.
hearing coming up.
You're going to
She's
get
not
one.
represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is,
Well, there's a final order about his
True,
his
he
obligation
did.
to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, on the cross-examination.
but it sounds like there's pending litigation, including a relocation or,
Pending
and I don't
litigation.
know because that's not my case. I haven't looked at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Oh, I'm with
Can you
you
approach
on
this for a
that,
moment?
Stacey.
Arguments and
All right. So this is what Brandon's talking about. This is what Brandon's talking about. This is the smoke show that he's talking about right here. Think she should have taken the deal. That's just me though, and I am with you on that. I'm not pulling for her. I just want a train wreck trial. Exactly. But yeah, here's the smoke show that Brandon's talking about. He's talking about this, this little hottie right here, with the fake boobs and the plucked eyebrows and the finely coiffed hair. She's couldn't you ask a relation? Not related to this, asking for suggestions. Yes, but where are we going to get lederhosen this time of night? Yes, go ask away. Ask away. I'm giving you a hard time. Any reasonable, sane person would have taken it, especially if you know you committed the murder, lied about it, and confessed to it, etc. Yes. But I think she likes life behind bars. It's so relieving for her. She gets 3 squares. She doesn't have to find a job. She gets all of the She gets all of the sex she could possibly want, because from what I understand is she swings both ways. Just saying, she's probably not worried about it.
All right, thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you?
Even my eyes went there. Just saying. Sal pointed it out. Well, anybody could point it out. I mean, you'd have to be blind not to see that. I think she honestly likes the friends she made per her letters. I think so too. Housing, clothing, food, sex. I mean, what more?
Mr. Owens.
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, the court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's
There we go.
representation of not seeking to utilize it, court takes no action on.
So in case you're wondering, what this is the Richardson hearing that they're going through. It doesn't take very long. All they're doing is they're breaking it down, seeing, forget about the sex. I mean, how would one put her own back hip back in socket? I don't know. Like maybe a kick to the butt. I don't know. Means she shouldn't be held accountable. Yeah, that's not the way it works. Shizzy, I laughed so hard I almost fell off your bed. Alone? Oh, sorry. She is sorry. She is this is part of the Richardson hearing. They want to make sure that they wanted to they wanted to run through these. Now they spent probably close to an hour in front of the judge and them actually talking about which ones they were going to cut, which ones they were going to keep. And then they came back to their respective tables, sat down, and they said, hey, we have to get all of this for the record. So that's all they're doing is making sure they get it for the record. Thanks for allowing me to ask that question. You're welcome. You're welcome.
On that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
So imagine this. They're asking about news coverage about Sarah Boone being arrested, put in handcuffs, and let off. Why? There's no, and I'm not an attorney, but I would immediately go in, yeah, this doesn't matter. Jesus God, I have no man. Yes, you're alone. I think we're alone now. Damn me. Took 3 doctors 3 times over 2 days to set mine. Ooh.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the rule?
So they need to
There
move
is none,
this
as the
handle
defense
out
has
of the
advised
way
they are
right
not
here.
seeking to enter it into evidence.
It's disturbing me.
32,
that
another
Sarah-
iPhone photo file name. It's very long, so I'm not going to read it.
This does not intend to introduce.
Okay. As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection. State any response.
Any and all exhibits previously listed by the state?
Yes, sir.
This is going to be a mess. He's about to get lambasted by the judge.
Judge, Mr. J is a smart lawyer. A
Well,
lot
no
of
shit.
experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday,
Twice.
we were forced to disclose the overt act that constituted our defense that tied in with the self-defense.
This is
And
gonna
so
be a shit show right
practically, he
here.
was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details.
I'm sorry to hear that, Tammy. I thought you were talking about the chickie baby. No, I don't know. I don't know any. I'm no medical doctor, but I would say go see a doctor. You might have to get something replaced. Hip replacement, I guess, is the only way that I know of. My wife's aunt had her hip replaced. She was not able to walk properly for quite some time. She walked with a really weird limp. She went and had her hip replaced, and now she's dropped like 30 pounds just because she's always been very active. She was down for a little bit, but yeah, that's what she did. That's what she did. Got that taken care of, and now she's out walking with the pups and getting exercise. And she's 76, 70. I would say she's 73 now, I think is what she is. So yeah, the Boone stuff is comical because this guy's about to get his ass handed to him. Hey Zach, what is up? I'm just looking for another glimpse of some chalky white cottage cheese alky legs. They're mine, not Baker's. Thank you, Zach. I got something for you, Zach. If this will make you feel better. This will make you feel better. We'll get you some chalky legs here. Here,
The one with the black hair, is your name Emerson? Oh, that's weird. It's Emerson big old titties, you know what I'm saying?
Thanks, Zach. I appreciate you. Oh, that's awesome. I get a kick out of that one. That one makes me laugh every time.
Of what they allege, Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that.
That's his job.
But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constitutes.
Oh, this is a bad idea, and I'm going to slow it down because this right here is about to be really bad. 31 watching, 37 likes. Guess I can't yell at y'all. No, I got 51 people watching right now, Zach. Might want to refresh that. But yeah, this is, she actually did, this guy is about to get his ass handed to him on a platter. Oh, it is gonna be just a mess. It's gonna be a mess. Oh.
Constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So
you're about to find
in
out.
an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know
You're about to
what
get
it
him.
is exactly that the state attorney is
You're about to get
alleging
him.
that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly
You're
to
about to
this
find
point,
out.
which is they want to know why we want these documents and what documents specifically
You
are y'all
ask
going
and
to
you
use.
shall receive.
Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir.
Oh boy. He is about to get his ass handed to him in the most glorious way. This is going to be the slap down of all slap downs. If you haven't seen anything, well, grab your popcorn, get it all nice and tight, get it all snuggled up close to you. Get it all snuggled up close to you because it's going to be worse than this right here.
Oh, a lovely lady. Hey, baby, you're all right. You must have been something before electricity, huh? Okay. Well, the last time I saw a mouth like that, I had a hook in it.
Oh yeah, that's how he's gonna feel. That right there is how he's gonna feel. He is going to get the taste. He is going to get the taste, and it is going to be just so glorious. So glorious. He's about to get it. All right, let's do it.
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version.
You say you want some coffee? You want coffee minute? Everybody need a pee break. Everybody need a pee break. How about we set this up? How about we do this? We'll go ahead. We'll give you guys just a little bit of a break. I got to pull it from the morning stream because I don't have it here. So here we go. Everybody go grab yourself some coffee, some tea, some beer, some alcohol, some liquor. Relieve the bladder. You've got about 5 minutes.
Sandy shores, get a tan, ramble the orangutan.
driving a golf cart. Oh man, Rambo is half crazy, yes he can. Well, that SOB's a sight to effing see. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Whoa, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is, well, that is too dirty to say here. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is that is too dirty to say here, Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Otters in the surf, hummingbirds in the sky. Rambo honks the horn and spits in Shizzy's eye. Oh my! Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Oh, Rambo's rolling. Rambo takes a turn, driving to the wave. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having a effing blast. So here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too. Well, here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too.
Oh yeah, and we're back. Here we go. Ah, Chad. Now you see you got a chance to get. You got to start stealing them off your line. You got to start stealing them off your line. That's awesome. I love it. I love it. See, kickboxing man got to dance in there. Oh yeah. Oh yeah. Well, they asked for it. They're about to get it. Here it comes.
And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there, the rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, "I can't breathe," the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, "Judge, there's been no change in her testimony." Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, Jorge Torres, George Torres, died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. Damn. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
Imagine that they've been delaying this for this many years. So this, not saying he was a saint, not saying he was perfect, but this human being can get some sort of justice, where the family can get some sort of justice for what he just described. And that right there should be, she should have taken that plea. That was a sweetheart plea deal. but now that's going to be shown in front of the court.
I wanted that in writing weeks ago. She was assessed,
You didn't need to have any of that in writing.
Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with.
Oh, really?
There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2
Yeah,
prosecutors.
She's twisted.
The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone.
Uh-huh.
We dispute their characterization of what she said.
Oh, really?
That's just going to have to be testified to by Sarah Boone and then Dr. Warner. And the jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question
Anything happens.
that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder.
He gave it to you
Something I
months
was
ago.
asking for a couple of weeks ago.
He gave it to you months ago.
Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on
She
its same
doesn't seem
ruling
a
in the
bit
case law
concerned.
identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure it meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your
She's
response,
a sociopath.
Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
The state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents.
Exactly.
The deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay.
Well, and here's the thing, Tammy. That part is on video, but her hitting him with the baseball bat is not on there. But the medical examiner is going to be testifying as to the amount of abuse that the body took. That it was hit with a baseball bat. That it caused damage to his face, to his jaw, to the left side of his body, the right side of his face, the left side of his face. Remember, lots of chicken hollow. They don't get it over your skis on the spice level. There are more pleasant ways to not feel your face. Oh, that's bad. It's bad.
Is that accurate, Mr. Owens? That October 3 states list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose them. based on what Sarah Boone has asked us. I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not.
Sweet. Welcome, Nick Raiders. Welcome, Raiders. Good to see you. Good to see you. Good to see you. Oh my gosh. Just come flying on in like a wild bunch of banshees. I love it. I love it. I love it. Welcome, Nick Starro. It's a U-raid. Purple to black is hard to read. Purple to black. Well, it is, if you're colorblind, it might be. Was morbidly obese 15 years ago. Understand the diet thing, lost 180 pounds. Well, congratulations. That's awesome. Hi, all joining us. Welcome, Raiders. We are covering just the final few moments of Sarah Boone. And then we might do something off kilter after that. You never know what's going to happen over here. Yes, I see Nick is here. I see Nick has been, just having a wonderful time of it. I'm sure that YSL trial is just lots of fun, Nick. It's just crazy. Oh my God.
We're going to call them. The law says, the case law says, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. Oof. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not. We may not call.
Huh? What? I got distracted by this. I'm sorry. I missed something. I was paying attention, and then the next thing you know, I'm not. I got distracted. Let me rewind that a little bit. Sorry about that. Just it happens.
Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which.
Yes, it does look like she's having a hard time keeping her anger
she
in
may
check.
want some witnesses. She's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not. We may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount, and she does not have the right.
I can see her belly button.
Thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Nick's good people. This will be short-lived. See?
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Yeah, he's right.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence.
Oh boy.
Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir.
Yeah, needs to be.
With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response Those witnesses will be excluded if not deposed
Yeah.
prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. And what I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please?
Sarah is broke.
If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called.
And that really is it. There's nothing else beyond that. It's just them getting rid of a couple of jurors. And that is pretty much all that there was left of all of that BS. There was, I mean, they did somebody else I think believed while they were doing the voir dire on the jury, they recorded those, but I don't see any need in playing that. It's it can be pretty boring. It does give you an idea of what they're thinking about and how they're feeling about this particular case. Whether they would make a good jury, it sort of gets you in the mind of that. But I don't feel it necessary to go down that road and go chasing that ghost. That's not for me. I wanted to see if I still had something here I wanted to show you guys. Where is it? Let me see if it's here. It was, no, that's not it. Where is it? Oh, that was the car interview. Okay, I did show the car interview. Okay, I don't have to do the car interview again. That's good. I was thinking that I hadn't, but apparently I did. I did have that one. All right, so I've showed George's brother, his friend Abraham, went over the Boone's property manager, which was just a total shit show. The interrogation of Sarah Boone's neighbor Vincent, which was weird. Her neighbor Brandon, remove him. Her ex-husband Brian, which was interesting to say the least. And then we have that one there that needs to go away. All right, that covers all of them at this point. But there was, I forgot to show this one. This one was brought to you by the Court TV. Okay, Shizzy, what kind of trouble can we get into? Oh, we're going to get into all kinds of trouble. So you may not remember this guy, but this guy right here. Yeah, this is the one here.
On January 3rd of this year, Deobra Redding leapt and tackled Judge Mary Kay Holthus. He was in court for sentencing for a probation violation connected to an attempted battery charge, which stemmed from allegations that he had attacked somebody with a baseball bat the year before. Moments before the courtroom attack, Redding asked to stay on probation instead of being sent to prison.
Based on my criminal history, I feel that I shouldn't be sent to prison for a second time. Have you looked at your criminal history?
Holthus did not like his criminal history.
3 felonies, a gross, 9 misdemeanors, multiple DVs. I'm in a better place in my mind, my mental, I have a support system. I just got hired as a teamster for, a union.
After stating his case for leniency, Holthus began to sentence him to prison.
I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court.
According to court documents, Redden punched Judge Holthus in the head and pulled her hair, and he punched a corrections officer multiple times and spit in another person's face. The court marshal who ran to help Holthus tripped as he tried to detain Redden, dislocating his shoulder and cutting his forehead, requiring 25 stitches. Redden is now facing a slew of new charges, including attempted murder, battery on a protected person, and battery on an officer. He invoked his right to a speedy trial and has pled not guilty.
He's also pleading not guilty based upon reason of insanity. Just like everybody else, and looking at the video, I thought Mr. Redden was either out of his mind or on drugs at the time of this incident. But after extended discussions with Mr. Redden, Ms. Springer, and other family members, I came to find out that he suffered from severe paranoid schizophrenia.
Redden ended up
paranoid schizophrenia? That's not what it sounded like to me. He said, F you, and went flying at her. Yeah, I can't blame the clerk, but the cop, come on, man.
Appearing in front of Holthus one more time to finish the sentencing hearing.
I am making my calendar page from that day an exhibit for the court. Nothing's been changed, indicating the sentence I intended to impose.
Redden was sentenced to 19 to 48 months in prison, but now he could face decades behind bars.
Yeah.
Again, jury selection beginning today.
Oh, yeah. Yeah, that was like that guy got air right there. And I didn't need to see anything about this extra stuff. They're just rambling and showing the same thing over and over again. But yeah, that's just crazy. Brother wouldn't you run away if you were paranoid skits? I don't know. I don't know what I would do. I think I'd probably talk to the radio, or maybe I would talk to a camera, and then people would watch me talk to a camera. No, I'm not paranoid schizophrenic, but that would be wild, wouldn't it? Imagine if I was. It would just be, it would be an interesting thought exercise, or lack of thought, or something like that. It would be quite interesting to see. It'd be a little bit like,
fist yourself, you fucking idiot.
No. I'm sorry. I'm bad. Start yelling at the radiator for making fun of you is a logical move. I think so. I think that would be a very good logical move. Oh, that would get you a full sentence, and rightfully so. Well, I would imagine so. What I need is I'm feeling the need for some music or something here. Guys, do you guys want music or a game? That's the question. Would you like to play a game, or would you like some music? No, I'm not going to play the game. You guys are going to be involved in this one. You just got to tell me. You just got to tell me what you're looking for tonight. Let's see. We did some music. What kind of music could we do? Let's see. We could throw in a little bit of hip hop into no. You tell me. What would you guys like to see? Would you like to see something good happen, or something go bad. That's why they get paid. Reasonable doubt. Yeah. This attorney, he's got some serious problems. You want a love bath? Well, sorry, I can't give that to you over the internet. That'll get me banned off YouTube. Oh, that would definitely get me removed off of YouTube. But I think there's some. I'll have to look. I bet you anything that I have got something here that's going to be worthwhile. And oh yeah, I've got it. Got it right here. I've got it right here. I know exactly what we're going to do. I hope you guys are holding on to your horses, because this is going to get fun right here. Some old Squishy's Garden.
Well, so what you want me to do is you want me to take the chance of putting you on a scram tether, allowing you to get behind the wheel of a car, maybe having drank, and hurt or kill somebody. Not going to happen.
Court does call the case, People versus Nani Wesley.
Here we go.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Wesley. Nani, can you please state your name for the court?
Yes, my name is Nani Wesley.
Your Honor, we're waiving the preliminary examination. I know there's a bond violation hearing that needs to be addressed.
Yes, you need to address that now.
Your Honor, she will be acknowledging and admitting to the bond violation. And hopefully I can say a few words after that.
Go ahead.
Your Honor, I did submit some documents to the court. Hopefully Your Honor has had a chance to review those. She's been treating with the Home of New Vision since about April of this year, and she attends AA meetings pretty regularly. Nevertheless, this is...
When did you send documents?
Yesterday, Your Honor.
Okay, go ahead.
That looks like one of them. She's been treating with Home of New Vision since April. She's going to AA quite a bit. It is a struggle, though, Your Honor, and she admits the struggle. She has gone back to Home of New Vision. She has spoken with them. She's told them about what's going on. They're giving her some things to do to redouble her efforts. I'll just give Your Honor a minute to read if you'd like.
Oh boy, she's in trouble.
Go ahead.
They've had her go out and get a sponsor. She's been working with a sponsor now. I've attached a letter from her, Your Honor. She's really been pushing Nani to get new strategies in place, new ways of dealing with things, new ways to address her thoughts and behaviors as it relates to drinking. And she appreciates that pushing from the sponsor, Your Honor, and she can tell you that as well.
Go ahead.
She has been putting in some very serious hard work, Your Honor. We're hoping that the court can take that into consideration and please give her a second chance at this, Your Honor. She went to Home of New Vision again this morning, and they hooked her up with a recovery coach. She gave me her card from her, and she says that they've been also giving her new strategies as well in dealing with this. So she does admit the violation, Your Honor. She is a bit ashamed of herself, given that she's trying to put in a serious track record to get to this point. But yeah, she's dealing with it as proactively as she possibly can.
Well, then when it was asked about, why didn't she just say what happened?
Freaked out, got nervous. It's no good excuses for it, Your Honor.
Well, but there were numerous times she could have, like a better term, just come clean on it. She didn't do it.
It's hard.
It's not like they just asked her once, and they wanted her to take an ETG, and she sat there and skirted around all of that.
She got scared, Your Honor.
I imagine so.
Just let them do anything.
Your Honor, the concern of the people here is that this is a true fourth OWI. Priors in 2005, 2015, and 2018. The alleged BAC at the time of the stop for this case was a 0.214, and we have a confirmed drinking event while she's on.
Holy cow.
The public safety risk defendant poses is extremely high. People are concerned that if she's not put on a scram, or if there are not other steps taken to make the public safe about what might happen. This event, fortunately, it seems like it is being taken seriously. History of the defendant with alcohol cannot be ignored by the people. We are requesting either a remand or a scram tether installation before she leaves this immediate vicinity.
How come she didn't take the ETG?
Right then and there, Your Honor.
Hmm?
Right then and there, Your Honor. She did take the ETG. It came back to onsite.
At what point?
I don't know that, Your Honor. Yeah, you of course can talk when the court's ready for you. Yeah. Are you asking Ms. Wesley?
I'll hear from her.
Okay.
Your Honor, I did take it the same day that I was asked to take it. I wasn't in town. I told her I wasn't in town, and she said that I needed to take it, which I did do. I came back to Ypsilanti to take it. I was not in the area.
I guess my question, you took it on what day?
The same day that she requested the 3rd.
Why didn't you tell her you did?
Yeah.
I did tell her, Your Honor.
When?
I told her,
What? Okay, let me ask this. Why was your story changing?
I was nervous when she called me, and I told her that I wasn't in the area right away. And she said, well, where are you? And I said, I'm out of the area. I'm up
Judge
north.
Main's good too.
And she said, well, your device isn't up north. It's in Detroit. And I told her that I would come back if she needed me to. And she said, well, I can give you some places where you were at to test. And I said, I will try to make it back so I can do so. And I did do that. I did it the same day she asked me to.
Your Honor, if I may, the report that I received does indicate the testing has been on-site, not community corrections. And I also have that same information, I think the court has as well, where the initial information that's provided by the defendant to community corrections is that she was up north and unable to do that. But that 20 minutes before this contact, GPS and Soberlink said she was in Detroit. And then the defendant said she didn't have it with her, Soberlink.
I didn't physically have it with me, Your Honor. I wasn't with the SoberLink. That's what she was asking me, the corrections officer. And I told her.
Where up north were you?
In Dryden, Michigan.
In where?
Dryden.
So, Your Honor, I mean, bottom line, she did come back to do the ETG knowing that it would be positive and knowing that this court would take that into account. She has been scrambling this past week to try to get things into place. I think with everything she's been doing since April, with what she's doing now in combination with the scram tether would keep her on track, Your Honor.
How is that going to keep her on track?
It'll make sure that she can't drink.
No, she can still drink.
We'll tell her she does.
I promise you.
Much like this did. And then when they call her on it, she starts all kinds of excuses, Mr. Allen.
I'm begging you, Your Honor, I will not.
That's right, beg.
At the time, did not have a sponsor in place. I have a sponsor now. I'm working with Home of New Vision on a weekly basis. I see the treatment coordinator. She did submit a letter to say that. I told her right away.
Ma'am, this is the fourth time. Then you get caught the fourth time. You're almost 3 times the legal limit. You get a bond. You're out. We put you on a sober link. You drink. Then when you're called on it, you begin this whole thing of going around it and everything. And that's what gets you into treatment.
Well,
So what you want me to do is you want me to take the chance of putting you on a scram tether, allowing you to get behind the wheel of a car, maybe having drank,
Your Honor.
and hurt or kill somebody. Not going to happen.
Your Honor, I won't do that. I have.
Bond revoked. Defendant's remanded. I'll adjourn this out 1 week.
We are waiving the preliminary examination.
I'll
Your Honor.
adjourn it out 1 week. She can do the waiver then, but she's going to do this now. October 24th, 2024, 9 a.m.
Oh, I guess she didn't like that too much. Oh, buddy. Sound like she was slurring her words right then and there. Yeah, Judge Simpson, he doesn't like to play around with that kind of stuff. He's just like going, sweetheart, what were you thinking? You thought you were going to get away with this? Oh, boy. Oh, boy. Yeah. Oh, we've got conspiracy theory Karen. Ooh, this ought to be good. We've got conspiracy Karen. She sounded like she was slurring her words. Ooh, this is good. I'm working on a song for you guys, so you just bear with me.
She posted that other one that we put on about Yolanda, that Yolanda, my client Yolanda Brammer, needs to off herself.
Evictions for now. So we've got
What?
Yolanda Brammer versus Heather Godwin on an indigency contest. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay, Mr. Akhtar, is that correct?
Yes, Your Honor.
Who are you here on behalf of?
I'm representing Yolanda Brammer, the landlord who successfully got the default judgment of eviction.
Right, let me pull that case up. Okay, hold on. I've got a copy of the judgment right here. It was a default judgment for $12,228. Is Ms. Goodwin here?
I am, yes.
Okay, you had filed an affidavit of indigency with regard to the appellate bond.
Yes,
And, the plaintiff entered a contest to that.
Yeah.
And so that's the hearing today is with regard to contesting the affidavit of indigency.
Yes.
Let me find the case here. It appears that the judgment was entered on September 30th for $12,028 plus possession. And it was a default judgment because the defendant did not appear. But you went ahead and put the 1 month's rent into the registry of the court. And then you filed an affidavit of indigency with regard to the appeal bond, which is going to be close to $25,000, correct?
Yes, Your Honor.
I believe the appeal bond is $4,100, 2 months rent.
Oh, they just put 2 months rent. That's right. This is an eviction case. So it's 2 months rent. So, the rental is right. So the appeal bond will be twice the rent. So it's, $4,100. Okay. Okay. Initially, the affidavit was granted, but then Judge Holmes pulled it down when they entered contesting it. Okay. Let me swear everybody in. Do each of you swear to tell the whole truth and nothing but the truth?
I do.
Okay. Did you want to present anything in addition to the affidavit, Ms. Godwin, in your,
Sure.
Okay, go ahead.
Let's see.
Oh, boy.
I have an exhibit that I
Sounds
sent the
wonky.
court. Do you have that exhibit in an email? Exhibit
When
T1?
did you send it? When did you send it?
I sent it last night.
Okay, we would not have gotten through it to get to here. It goes in the general email, so.
Okay, so let me pull that up in my computer. And I'll show you my bank statements.
Can you let her share the screen, Miss Monique?
She should have access. I didn't. There we go. Yep.
Okay.
All right.
Okay.
Here we've got my declaration. The total available in my bank is less than 200. It's 197.77.
Okay. That means what?
Also, I need to amend my affidavit or just add through this testimony that the $600 a month that I was receiving from attorney's fees due me, that were being paid on a monthly basis, that is now $300 because one of those debtors had an accounts receivable account open with him where he was due to pay me about $3,500 more in fees at $300 a month. And on October 8th, I sold that out for $1,200 cash.
What?
In order to put the rent into the registry.
Imagine this lady is.
So
oof,
that is a reduction in my monthly income. And I do have a Rule 11 agreement that I could show the court if the court would like, but
you kooky
I can take your
woman.
word on it.
thank you, Your Honor. So I'll just take a quick look at my banking. This is my PNC bank account activity overview. And you see here in my current bank account that I use, it's the 9-1. I have an available balance of $8.79. What's interesting is that this second account, it is a bank account that I abandoned in 2022 when I left my previous employer. And PNC is also the bank that my previous employer uses. And I was getting hit with so many overdraft fees that I just kind of took whatever funds were out of that bank account and I moved to Horizon. And so when I went back to PNC, just because it was convenient to, this bank account was there. And it's been there since 2022. And I asked them, they're like, oh no, you don't have to pay it. You don't have to pay it. It'll just fall off. And now in retrospect, I'm wondering, why hasn't it fallen off since 2022? And I kind of think that
like
it's
9 years or some crap like that.
Because
you crazy.
Well, never mind. But anyway, that is not a functioning account. It does not have $1,900 in it. It actually has an available balance of negative $88.39. And I'm just waiting for the bank to let that fall off, which I don't think it really ever will. I think it's a signal to other financial institutions not to grant me credit. This is my Horizon business checking account. I have a available balance in it of
she sounds drunk.
Of $186, $187. So that, in addition to PNC, leads me to the 190.
Yeah, sounds like a scammer.
Okay. All right.
And there's the Rule 11 agreement with it, where I went ahead and sold that debt back to the client. I'm back to the opponent. So I'm poor. I can't afford the $4,100. If I could afford my rent, I would have been paying.
Sweetheart, you just grab them pearls, sell them. All that art you have on the wall behind you, sell it. All the pretty lights. Get rid of the nice computer. Get rid of all of that stuff. You can pay it. Mm-hmm.
In the rent, but so I need to appeal. I'm also filing. I found out about disappeared on my phone a retaliation case that had been granted, even though the plaintiff bringing the case was delinquent. So I'm going to file that retaliation case and hope that the county court can abate and deal with those cases. Concur, I don't know what the procedure is, but and I'm also appealing the dismissal of the trafficking
Yeah,
suit.
she's a total scammer.
4818 in the
God.
district court, which I'm sure Mr. Akhtar is going to discuss at length. Although it's irrelevant, I'm going to go ahead.
Well,
and
if you're wondering why you
object.
can't type anything in
I just
there,
wanted to let you know, yes,
you've been a
I'm for.
sub for a while, and
Okay, thank you.
I'll let you guys know we've recently been hit pretty hard with a bunch of trolls, so there's just a time limit on there. Don't worry, you'll be able to chat soon. We'll be here for it because we're gonna do some music also tonight. You'll love the music. It's good.
Thank you very much.
Thank you.
Did you want to present evidence or question anything, Mr. Akhtar?
Yes, Your Honor, we have some evidence to present in the form of Ms. Godwin's own filings and a number of other posts and things she's done, which I think seriously impeach and undermine her credibility in this indigency claim. So let me go ahead and start by sharing my screen. I'd like to start by pointing out, and I hope that's the right size. It's interesting that even after the eviction was granted, Ms. Godwin evidently decided to file a first amended answer and plea in abatement and motion to dismiss. Ms. Godwin is a licensed Texas attorney, which the court, I'm sure, is already aware of. So she filed this after the eviction was already granted, and again claimed that the indigency hearing should not go ahead. Ms. Godwin,
Your Honor.
Ms. Godwin, I did not interrupt you.
Oh, okay.
In this pleading, again, she makes bizarre claims, like in the filing of her affidavit of inability to pay, the e-filing site was a honeypot that was trying to capture her information or whatever. That's fine. That's not terribly relevant, but this is relevant. Ms. Godwin herself claims, as I've highlighted here, that she's such a busy family law attorney with such a busy active practice that the 20 hours that she prepared in order to fight this eviction case was valuable time that she could have spent preparing for trial in all her other busy family law cases. And that time was wasted in defense of this, quote, meritless suit. This meritless suit that, of course, she lost and she didn't even bother to show up for. That's important because, again, I'm going to show her sort of pattern of abuse of the system and her multiple bizarre and contradictory filings. So
Counsel, if she files crazy filings, what has that got to do with how much money she's got?
Well, so in this one, she claims that she's a busy family law attorney with many active cases. Now, it's also worth noting in the second exhibit that we sent the court that the reason that she could not make it to the first setting on this indigency hearing is because she was set as attorney in another case. Again, she files under oath that the reason she couldn't make the October 10th setting and it had to be continued to today was, again, she was an attorney of record in another family law case. So again, that seems to go along with her claim that, yes, she's a busy family law attorney. Then, if we look at her affidavit of indigency itself, I have to point out that it states that she makes zero money. Not a few hundred, not a few thousand, but if we go to the actual affidavit itself, she says, I'm sorry, I need to get to the part. Yeah, here we go. My take-home pay is zero in monthly wages. That cannot be true. That cannot be true if what she has filed under oath in other cases is that she's a busy, active family law attorney with busy cases and deserves to be paid all the fees that she had to lose out on because of defending in this eviction case. I'd also like to point out that the amount of contempt that she's showing for this court and the amount of gamesmanship is relevant here because the eviction was granted by default because, as you can see here, she posted later on Facebook after not showing up for the jury trial that she demanded. And the jury trial, again, was her attempt at kind of pushing off the eviction trial because, of course, it pushed it off another 2 weeks. She did not even bother to show up for the jury trial, so she wasted the court and the jury's time. And here she admitted there really is no defense in Justice of the Peace Court for me. She finally admitted that, but then again, she later turns around and says this was a meritless case that she had to defend against, and that's why she deserves to be paid thousands of dollars in attorney's fees. It is just a pattern of serious impeachment of her credibility.
Yeah.
I also have to point out a couple of other things. She sent me emails which are relevant to this whole issue of credibility and her meeting her burden about whether she's got money or not. Here, she points out that my client trying to evict her is, quote, like all the other landlords did when I resisted. This is her MO. She's got some conspiracy theory going on that everybody's out to video surveil her and traffic her nude videos on the internet, and that every landlord and every home that she's ever lived in, they're all participating in this conspiracy. I also have to point out another email in which she has threatened to go ahead and add me to this federal suit for trafficking. If she's so indigent and she doesn't have any money, how does she have the money to file all kinds of suits in JP, in county, in Travis District, and even in U.S. District Court for the Western District of Texas, as I will show, Your Honor. So here she is threatening to sue me and add me to the federal suit for trafficking, claiming that somehow I'm now part of this conspiracy to hack her computer and video surveil her.
Whoa.
This licensed Texas attorney, after my client successfully got the eviction, is actually posting on Facebook that my client needs to off herself. This is how a licensed Texas attorney is behaving.
Is he offering these exhibits, or is he actually arguing the exhibits?
I've offered the exhibits and I'm summarizing them for the court. As far as the case that she's
I'm objecting to the exhibits.
As far as excuse me?
What is the objection to the exhibit, Ms. Godwin?
They're irrelevant.
You know, they're very relevant.
Again, I'm showing all of these as relevance to her lack of credibility and impeaching her claims that she's got no money.
They're irrelevant to the fact that I have no money.
Overruled.
Oh,
thank you.
Thank
and
you.
then as far as the district court case that she mentioned, I kid you not, I can't make this up, Your Honor. After my client filed the eviction case in JP court, Ms. Godwin rushed off to district court and filed a $20 million lawsuit against my client, again, claiming that she's part of a global video trafficking conspiracy to surveil her and sexually exploit her. The claim was so ridiculous that we went to hearing on it. Judge Meacham in district court awarded my client back her attorney's fees plus $1,000 in Rule 13 sanctions. So again, if we're talking about meritless cases and Ms. Godwin dares to use the term meritless lawsuit, this should tell you, Your Honor, what kind of pattern of lawsuit abuse that Ms. Godwin engages in.
Yeah.
I will next point out, and again, I just want to make this very short and simple. I know this case has a very tortured history. Ms. Godwin has done this again in U.S. District Court for the Western District of Texas. And she's gotten cases dismissed there for filing the exact same types of pleadings against other landlords and other attorneys who represent those other landlords. This was one that got dismissed back in May of this year. This is something she filed in federal court against the Parks on Brody Lane, which is another former landlord of hers, and Forrest Cook, an attorney. She also decided to file against Facebook, now known as Meta. And it was, again, based on all the same bizarre video surveillance conspiracy claims. And at the end, I just want to show the court the highlighted language that court warned her from filing and pursuing further frivolous lawsuits. But that has not deterred her in the slightest. She continues to do it. She is a menace to the judicial system.
Menace, I tell you.
Now, as to her claim of indigency, I don't think people who are indigent, Your Honor, go get Botox treatment and Botox injections and post about it on their Facebook page.
Your Honor, that Botox I got in 2012. It says here from the Botox, scar tissue from the Botox. That is, I have scar tissue in from Botox that I received over a decade ago in my forehead. And I cannot, and I'm doing
Okay, I'll give, Ms. Godwin, I'll definitely give you a chance to respond, but I'm just going ahead and I'm submitting these. This was posted within.
Irrelevant.
You'll have a chance to respond in a minute, Ms. Goodman.
Thank you.
So I can, she said irrelevant. I contend that that's more than relevant to showing the money that she has and the money that she's spending.
She's trying to do Facebook, yes.
Counsel, do you know when that picture was taken or when that posting was made?
Yes, that posting was in the past week. All of these postings that I'm showing you are just within the past week.
Jeez.
Another one. People who are indigent and broke don't go out to eat oysters, Your Honor. Oysters, one of the most expensive foods you can go out to eat, and then post a food critic style review of the amount of Parmesan cheese that was on them, whether they were lukewarm and hard, how buttery they were, or whatever other nonsense that she's posting. People who are indigent and broke are eating grilled cheese and vegetable soup at home from the grocery store, or if they're going out to eat, they're going out to eat very inexpensive fast food if they have to. They don't go out to eat oysters and then post about it.
No.
And
God. I just want to see this
I don't know whether
face.
this is relevant or not, but she's
Her
continually
reactions.
posting things which are very threatening to my client. She posted that other one that we put on about Yolanda, that Yolanda, my client Yolanda Brammer, needs to off herself.
I did not post that she needs to off herself. I believe that karma is going to come around to this woman. I
Ms.
don't know.
Godwin, you'll have a chance to respond in just a minute.
Okay. So I've shown all the exhibits I need to show, Your Honor, except I will mention that even Ms. Godwin herself mentions that she's not done. Oh boy, she's definitely got more lawsuits on the horizon for us.
Sounds
in
like
her email
balls.
where she sent her D1 exhibit yesterday, she once again says that she's going to be coming after my client again in a forthcoming federal trafficking suit that I will file once I flee the state. This woman is a menace to the judicial system. She seems to have all kinds of money to file lawsuit after lawsuit after lawsuit and judicially harass and extort people, yet somehow she doesn't have money to come up with an appeal bond. She filed an affidavit of indigency which said she had zero money coming in, which we know has to be false if she's also filing under oath that she is a busy family law attorney with active practice of many, many cases, and goes out to eat oysters, does Botox, and has more lawsuits planned on the horizon. It's truly amazing. And let me point out that if she filed the affidavit of indigency and claimed that she had zero money coming in, that was weeks ago.
G. Good to
How
see
did she
you.
all of a sudden come up with $2,050 to finally pay rent? Please understand, she has not paid rent for 4 months, June, July, August, and September. Now, finally, she goes ahead and she pays 1 month's rent, $2,050. Where did that come from if she says she has absolutely zero money? If she can pay 1 month's rent, she can certainly pay 2 months' rent for an appeal bond. I'm not saying she doesn't have the right to appeal, Your Honor. I'm simply saying that if she's going to appeal, she darn well needs to pay her appeal bond because my client needs to have some surety of finally getting some money and being rid of this deadbeat who hasn't paid rent for 4 months and who does nothing but file lawsuits all day long against anyone and everyone. It's appalling.
You want to respond, Ms. Goodman?
Oh boy.
Yeah.
This should be good.
I did have a trial on October 10th. It was a pro bono case that I took, and I expected attorney's fees out of it because it was an enforcement. However, facts arose at trial that turned those tables, and I did not receive any attorney's fees. And after that trial, I did go out with the client who needed a drink. So we did go out. I have been piecemeal getting money out of selling my possessions. It's very, very slow. I got extension. My utilities have doubled because of the crack in the foundation here. I was able to get extensions on the electricity bill, which is now $400 a month. And it used to be about 180 because of the
Whoa.
water leakage down into the
Katrina
ground
owner.
and that by Texas.
That's right.
So that's not due until the end of November.
So good, Betsy.
I was able to get an extension on the gas until the end of this week.
She's got a lot
that
of gas. It's
bill
leaking out of
is
her mouth.
twice as high because of a break in the gas line.
Oh,
I had
break in the
Texas
gas line.
Service come out, and I had told Ms. Brammer back in July of this year that the foundation was shifting, and she didn't do anything about it. And now we've got
On that issue, I have to object.
a
Repair and remedy is irrelevant.
it goes to the amount of my gas bill. It goes to the amount of my utilities that I've had to pay because and my utility bills have gotten higher and higher since July.
So
that's where my money's been going, to doubled utilities, Mr. Akhtar. And so I do, the selling off of my possessions is piecemeal and haphazard, and I really don't have the money. I really don't. I sold off a $3,500 accounts receivable for less than 50%, for like 1/3 of what it's worth, and let that opponent go, let that debtor go. I don't have the money. So as far as the trafficking case being that his motion for dismissal granted, all through that hearing, Judge Meacham was saying appeal, appeal, appeal. And it is systematic corruption in the music industry with powerful people in the city that are supporting what's happening to me. Ms. Brammer admitted in a text that it's happening to me. She put me in this house with a broken lock, with a broken security lock. You said it was a good case. Take my damages where I can get unlimited damages. I did. I filed suit, got the motion to dismiss all through the hearing. Meacham saying appeal, appeal, appeal. And that's because Meacham herself is under stress to dismiss my case. She did. It dawned on me yesterday as to why she was saying appeal, appeal, appeal. It's because she wants me to appeal it. It's because she can tell the venture. I dismissed it. The appeals court told me to hear it. I think that at the trial now, I finally, after 20 years of being an attorney, I finally realized that at the trial court level, it's dirty. But once you get to appellate court, things get a little bit more up and up because the appellate court doesn't want it in writing what they've done. They don't want, the appellate court is not going to want make jurisprudence that says a landlord can put a tenant in a house with a broken lock and have her trafficked. And then when she complains about it to her, say, yep, you're being trafficked, and that be okay. What? The appellate court is not going to, that's horrendous. The trial court might let that happen because nobody's looking at what the trial court's doing.
I think Ali Akhtar just took a rubber band and snapped it. And that just was like the last thread of her brain. As I am not following what she is rambling on about. Her drunken incoherency. Lady, lay off the lewds.
It's dirty. But the appellate court is not going to want that, let that be jurisprudence. And I'm filing my notice of appeal today, and when the appellate court comes back and says to Meacham, hey, no, we're not going to let that ride, Meacham's going to let my case go forward. That's what's going to happen. I don't have the money right now. I am under my Google verification cannot stay. I do not have a search engine. I do not have ability to pull in clients through a funnel like that.
She needs a padded room.
I spent $8,000 on marketing. $2,000 a month on marketing to try to get a client funnel to me. I cannot get it because Google keeps messing with me. Will not let my verification stay, and I can't get clients. I am being pushed in through tech and through corrupted landlords. I am being trafficked and pushed into prostitution by the music industry. That's the hallmark. I have a witness who told me, and I'm not going to say the musician's name, but she said, "Have you ever heard of Jane Doe?" That was told to me in 2019 when I went to this witness for help.
Wow.
She was telling me that you are like Jane Doe, a very successful musician here in Austin. You are like Jane Doe, and you are on that track. Congratulations. And I'm just, no, I don't want it. But they will not let me go, because at this point, I am a darling for misogynists who love to watch someone who does not want to be watched, and they are raking in the money. So they're liking this. They're liking this.
I don't know what she's rambling on
Well,
about.
let's get back to the issue. Do you have any additional evidence to show that you're indigent?
I don't have any.
Okay. Okay, that's fine.
And the Botox, if you look at that Facebook post, it says Botox scarring. This right here, this binge looking thing right here, that is a piece of scar tissue from where the needle went into my head, delivered poison, and killed all the skin around it and made like a little brad of scar tissue, dead skin that I'm trying to work out of my face so the elasticity can return. And this type of plastic surgery, it's new on the horizon. No plastic surgery. You just manipulate the fascia on your face. It works. However, I've got Botox stuff. Botox and fillers severely hinder it because they impede fascial movement. I've got Botox brads in my brow that I'm having to work out.
Botox brads in your brow.
I did not get Botox. I got Botox like 10 years ago.
All right. Okay.
Your Honor, may I make one final rebuttal point based on something she just said?
Quickly.
Yes. So again, now she's just testified under oath that she spent $8,000 on Google marketing, $2,000 a month. So she just testified to that under oath. But again, she wants you to believe she's got no money.
That $2,000 a month was a year ago.
Well,
and I had, because I had a whole bunch of cases that came with me from my family law, from my employment, because I told these people, hey, I'm working for an employer that tried to get me to steal $7,500 from a potential new client, and I'm leaving him. Do you want to stay there, or do you want to come with me? And they all made the informed decision to come with me. So I have that cache of cases that I have been living on. And on those fees, on those fee retainers and that work that I did spend $2,000 a month to keep a law practice running. And that is thrown away money.
Why didn't you move?
Because Google would not let my verification stand.
Yeah, it's on the record. Absolutely.
I did not have $2,000 last month to pay Scorpion marketing in order to help me get clients. That's like 8 months ago. I think that was like September 2022 to January of 2022. I got wise in January of 2023 that my Google is never going to verify, and I'm just paying Scorpion $2,000 a month for nothing. Got not one client out of it.
Okay.
All right. Maybe because you suck as an attorney.
Well, thank you, Ms. Goodwin, for attending and presenting your information. Thank you, Mr. Akhtar, for appearing and presenting your information. Based on the evidence presented, I'm going to grant the affidavit of indigency.
What?
The tenant, if she wants to stay in possession of the unit, will continue to be required to pay that monthly rental amount into the registry of the court if she wants to stay in the resident pending the appeal. Any questions about that? We'll have to go to the appellate court because we'll be turning the case over to the appellate court. Thank you again for appearing, and I hope each of you has a pleasant day.
Thank you, Your Honor.
That she actually got away with that? Oh my God. All right, here we go. This is for you guys. So I created a new one for you. All right. You asked for it, ladies. You asked for it. So here we go.
Get less up about the price so high. Steam beneath the painted sky. Candles flicker in the night. Everything's gonna be alright. Let's go. Bubble mountains rise so high. Steam beneath the painted sky. Candles flicker in the night. Everything's gonna be alright. Sinking down in liquid gold. World outside turns soft and cold. Letting go of hurried days. In this tub I lose my way. Hey, float away in bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low if you know, you know. Soap suds act like gentle friends. Whisper secrets no one sends. Warmth surrounds me, I'm at peace. Feel the soothing sweet release. Deep, so deep. Quiet hum of water flow takes me where I need to go. In this tide my worries drown. Lost until the lights go down. Oh no, no. Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low if you know, you know.
Do you have a fiddle? Do you play for her? I wish. I don't know how to play a fiddle. I'm sure I could figure it out. Oh, I gotta extend it now. Doggone it. So we have to extend it from here. And we'll go ahead and remove all of this stuff off of here. And I think that's right. Did it get, how far did it go? Let's see where it left. And I think it left off somewhere in here. Let me see. Double check.
Get less up about the price. Get less up about the price so high. Steam beneath the painted sky. Candles flicker in the night.
Do you have a fiddle
Everything's
you
gonna
play
be
for?
alright.
No.
Let's go. Bubble mountains rise so high. Steam beneath the painted sky. Candles flicker in the night. Everything's gonna be alright.
Dance, honey, dance. Well, you wanted to talk about bubble baths.
Sinking down in liquid gold. World outside turns soft and cold. Letting go of hurried days. In this tub I lose my way. Hey, float away in bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low if you know, you know. Soap suds act like gentle friends. Whisper secrets no one sends. Warmth surrounds me, I'm at peace. Feel the soothing sweet release. Deep, so deep. Quiet hum of water flow takes me where I need to go. In this tide my worries drown. Lost until the lights go down. Oh no, no. Float away on bubbly dreams. Nothing's ever
Yeah, I
as
think
it
I got it.
seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low if you know, you know.
All right, so I see where that's going, and I've got to get the last part of it here, and we're going to put in a hook. So just to make this happen here, put in a hook and bass drop, hook. Let's see, we'll do a hook, and then we'll do a bass drop. Let's see. We're going to do, let's see if we can make that happen. Let's see, we'll do a bass drop, and we're going to put in, add a fiddle solo for 12 bars. There we go. And we'll stop that at one. Let me make sure I've got this right here.
Let's talk about the price so high.
Doggone it. It's giving me a hard time.
Candles flicker in the night. Everything's gonna be alright.
Yeah, this is good. You love it?
Let's go. Bubble mountains rise so
Wait till
high.
you hear the whole
Steam beneath
thing.
The painted sky.
The whole thing's
Candles flicker in
gonna
the
rock your
night.
world.
Everything's gonna be alright. Sinking down in liquid gold. World outside turns soft and cold. Letting go of hurried days. In this tough I lose my way. Hey, float away in bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low, you know. Soap suds act like gentle friends. Whisper secrets no one sends. Warmth surrounds me, I'm at peace. Feel the soothing sweet release. Deep, so deep. Quiet hum of water flow takes me where I need to go. In this tide my worries drown. Lost until the lights go down. Oh no. Float away in bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low, you know.
49. 55. Yeah, 49. Yeah, 49. So it's down at 149. So we'll put that at 149. 149. And then we will take this one here, and we're going to put in a big outro. Big outro. Big outro. All right. All right. And let's see if this doesn't change it with a let's put in a fiddle. There we go. Fiddle, soldier female vocals, and let's see what happens. Yeah, we'll see if that actually works. 149, and let's extend that bad boy out and see what happens. Kind of reminds you of Megan's trainer style. Yeah. See, I can make these things. I can usually write one of these in about 5-10 minutes. Make them pretty good. So let's see what happens.
Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Getting feverishly wet.
That one's pretty good. Let's hear how this one does.
away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Get a feverish wet.
Oh, that's funny. Let's try 148 and see what happens.
Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Get a feverishly wet.
See if I can make it. You'd like to pay for a
Float
song?
away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Life's a kiss. Oh.
Ah, a little Saxon there isn't bad. You'd like to pay for Megan Fox to drive live by? Make that happen. That works. We'll see what the other one sounds like.
Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss.
We'll see how
This
this works.
moment, life's a kiss. Get a feverishly wet.
I like that one better. I still like the other one better. Yeah, we're going to do that one. We're going to get the whole song right here. So I got your Bubble Bath of Love. That one's for you there.
Float away on bubbly dreams.
And you get to hear the whole thing.
Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's
saw
a
that.
kiss. Life's a kiss. Oh.
All right, here's the whole song.
Get last up about the rise so high. Still beneath
there's the
painted
whole song.
sky. Candles flicker in the night. Everything's gonna be alright.
Here's your whole song.
Let's go. Bubble mountains rise so high. Steam beneath the painted sky. Candles flicker in the night. Everything's
Oh, it
gonna
doesn't
be
have to be
alright.
tonight.
Sinking down in liquid gold. World outside turns soft and cold. Letting go of hurried days. In this tug I lose my way. Hey, Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Down low if you know you know. Soaps act like gentle friends. Whisper secrets no one sends. Warmth surrounds me, I'm at peace. feel the soothing sweet release.
See, I have to do these every so often because I release new
Quiet
songs.
hum of water flow.
Usually about
takes me
once a
where I
month,
need
I'll
to
release a
go.
whole album.
In this tide, my worries drown, lost until the lights go down. Oh no, no. Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Gotta know what you know, you know.
I'm glad you love it, Tammy.
Float away on bubbly dreams. Nothing's ever as it seems. Close my eyes, I feel the bliss. In this moment, life's a kiss. Life's a kiss. Oh.
That's a good one. That one's gonna get saved for you guys, and we're gonna create a new playlist. Add to a playlist, and we're gonna create a new one. This is, let's see, I think we're gonna do a jazz album. How's that? Jazz album for chat. So every single one of them that we do over the rest of the month is going to be this right here.
Bubble mountains rise so high.
And that's how it started. That's how it ended. It's really upbeat. Exactly. Well, if I do one of these every night for the rest of the month, you guys will have an album next month. I can release it. No different than the one I did for Sarah Boone's that ended up becoming an intro. That one is pretty good. You guys get to hear that as we end this thing. Everybody, make sure you hit that like, subscribe, all that neat kind of stuff. And I'm sending you guys over to go see the expert. Actually, if Squid is still shown, let me double check. I think Squid is going tonight. Let me just double check on that really quick before I send you guys over there. I think, nope, she ended, but the expert is going on. So I'm going to change this up. I'm going to send you guys over to go see the expert, show him a little bit of love. I know the Umbrella guy is also streaming, but let's give the expert a little bit of love because, well, he's pretty damn awesome. Show him that you care, and everybody have a wonderful day. I will see you guys in the morning if you're around, and it's gonna be an interesting one tomorrow because I've got about 120 square feet of tile to lay tomorrow. Joys of joys.
Working tight, I curl and wait. You passed out, hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Are you feeling me? Lost inside, I feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. And please, breathing stuff. I'm almost begging. Please, grace the wrong. Don't leave me here. Lost my air in this gear. In this case, I disappear.